Welcome to Public Forum, a community outreach program produced at North Idaho College on the shores of Lake Coeur d'Alene. Featuring guests from around the globe addressing a wide variety of subjects, Public Forum serves to educate and enlighten. Please join host and moderator, political scientist Tony Stewart, in welcoming today's guest.
We are continuing our rather long series on a topic called Hot Talk, Passionate Debate for New Age, and it was our symposium topic this spring at North Idaho College. We have one every year. And we have several subtopics under that. And last week and again this week, we are discussing free speech and press versus censorship. And we have a longtime friend here today, and we're so delighted to have him, a very distinguished professor of law at Gonzaga University Law School. Our guest is Professor James M. Vacher. He has been a member of the faculty at Gonzaga University School of Law since 1975. And Professor Vacher earned a bachelor's degree from Washington State University and a Juris Doctorate from the University of Washington. He served as an Assistant Attorney General for the state of Washington from 1972 to 1975 and was Dean of the Gonzaga University Law School from 1986 to 1991. As we always do, we call you Jim, and we're so pleased to have you here to talk about this really important subject, and you certainly are very knowledgeable. Thanks for being with us today.
Thanks, Tony. Thanks for the introduction.
And I'm very pleased to have our two regular panelists, Janelle Burke, who's an attorney in the state of Idaho and a former student of Professor Vacher. And next to her is Erna Reinhardt, Director of Public Relations at North Idaho College. And the student will ask the professor a question.
My question has to do with the First Amendment. It's such a pleasure to have you here, by the way. And this is going to be fun. Professor Vacher was an outstanding instructor, and I know he knows this constitutional area well. What is the First Amendment? Explain for our viewers to set the stage. What is the First Amendment? And then secondly, what are some of the legal principles that have developed with regard to that free speech clause?
It's every student's dream to be able to ask the teacher questions, so I'll be happy to respond to your question. First Amendment is a provision of the United States Constitution adopted in 1791, shortly after the adoption of the Constitution, and it was designed specifically to prevent the government from regulating or over-regulating certain parts of persons' individual liberties, and that's speech, press, freedom of religion, prevention of the establishment of religion, the right to petition the government for redress of grievances, and the right to assembly. As a package, it really is often referred to, with the exception of the religion clauses, referred to as freedom of expression. And the whole idea is that because of the history of our colonial experience, primarily the drafters of the Constitution and the Bill of Rights wanted to make sure that every citizen had the right to freely express himself or herself, eventually, without interference from the government. And it really has two basic parts, the First Amendment does. The first is the prohibition against what are called prior restraints, where the government attempts to stop someone from publishing or saying something before they have the opportunity to express themselves. So you prevent the speech in the future. The second is a very serious, clear indication in the history of the First Amendment that what people have to say, the content of what they say, generally should not be restricted by the United States or the state governments. I want to mention really quickly that the United States Supreme Court has to decide cases like involving these issues every single session of the court, which runs from October to July of every year. And in the 2004-2005 term, there are some cases dealing with prior restraints, and maybe we can talk about those later.
Reinhardt.
Jim, one of the things that you said this morning that I thought was very, that struck me was that you said censorship restricts truth-seeking, and I thought that was very telling. Could you explain that to us?
Well, the idea that grounds that part of our consideration of the First Amendment has to do with the notion that, first of all, no one knows truth with a capital T, particularly when it comes to matters of open debate in any society. And the argument is, it was a metaphor used by Mr. Justice Holmes for the first time a long time ago, who said that the way to establish truth is through dialogue and through communication, and suppressing one point of view limits the search for truth, not necessarily establishing truth, but the search for it requires a kind of dialogue or dialectical activity between persons. And if you shut down one voice, you don't get there. That's the essence of that position on the First Amendment.
Great.
I want you to go into some explanations that you did this morning. I just really enjoyed this subject. There's some speech that's very much hate speech. And we've seen that in our country with extremists such as white supremacists. There's other speech that's disruptive. At gatherings, we've seen that also. And what I'm leading to, Jim, is a case that at the taping of this show, which is here in March, there's a case that's just been heard before the court that really relates to this. So for those who out there who believe that there should be rather broad restriction on this kind of unpopular speech or even that could be disruptive, what do you say to them when professors such as yourself say that there are First Amendment protections?
Well, the first thing to say is look to yourself. Do you want yourself silenced? That's always the first question. Is it your voice that you want silenced or someone else's? And if it's someone else's, you have to ask why it is you think the government should silence that person. The case to which you're referring, I think, is a quite interesting and wonderful case in which the famous lawyer Johnny Cochran sued a person who kept picketing around Johnny Cochran and yelling at him and making nasty noises about him and claiming that he was a crook and so on. And Mr. Cochran, the famous lawyer who represented O.J. Simpson, sued that person for damage to his reputation. And he won a judgment about that. But he didn't want money. What he wanted that person to do was to be quiet. And so he got the court to issue what's called an injunction, which says you no longer can say anything about Mr. Cochran in public. Well, that's an interesting circumstance because here we have a man who made his living as a good lawyer but also in the public eye trying to stop someone from talking. And the argument that the man has on the other side is, look, he's a public figure. I ought to be able to say what I want to say about him as long as I'm not injuring him directly. If I want to attack him for his positions, for his points of view, I ought to be able to do that. And I think the United States Supreme Court will agree with him because there's a classic example of a prior restraint where someone said, no longer can you speak in the future. You must be quiet. And I think every time we engage in that kind of suppression of voices, we don't deal with the underlying issues at all. All we do is silence people. And I think, for example, with other kinds of issues like hate speech or so-called hate speech or racist speech, to silence a person doesn't stop them from thinking those thoughts. It doesn't stop them from privately engaging in that behavior. It simply prevents the rest of the community from knowing where they stand and being able to deal with it head on.
Thank you. Janelle Berg.
We hear a great deal in certain circles about activist judges, and yet judges do not make decisions in a vacuum. Can you please explain some of the standards and how standards are arrived at in deciding constitutional issues?
Well, the first thing I'll respond by saying is that when people say they don't like activist judges, they really mean most of the time they don't like the way that judges are making decisions. Activist has been a label that's been attached to different judges at different times, regardless of their political or legal ideology. But beyond that, I think it's important to recognize that courts are in the business of interpretation and deciding cases. And inevitably, with general rules like the First Amendment, you can never precisely predict the outcome of any case because there are so many factors involved. Courts can't be active first unless someone asks them to decide. They are completely passive bodies. They must wait for a case to come to them. When it comes to them, activist judges, let us say in the United States Supreme Court, one activist judge has to convince 4 other activist judges to go along with him. So there are institutional restraints on judges. Furthermore, judges have training. Their temperament generally is to be very careful, and they always, at least, must try to justify any decision they make on a case based on what the courts have decided before. It's only in an unusual circumstance where the court might say, we reject everything that has gone before and decide anew. In our system, unlike other systems, the doctrine of precedent, or what went before controls, is an operating principle that has to be overcome. So if you combine the notion of the passivity of the courts, the notion of the institutional restraints that courts operate under, and the doctrine of stare decisis, it's a little bit too easy to critique for judges for being, quote, activist, unquote.
And there are certain standards that judges have to follow. For example, in a case involving pornography, there are going to be very definite standards that have to be followed.
No question about
please
that.
comment?
There are, in the pornography case, there are standards changed over time, but in that particular area, the law of pornography as it relates to the First Amendment has been pretty much established for about a generation by the court after some hemming and hawing over time on that issue. And the court, if it has a case today dealing with the question of obscenity or pornography, it must account for the rules that have been established in that case, which basically says that we presume against censorship, we recognize that community standards are important. If there's any redeeming value to a particular publication, it has to be social value, it has to be given First Amendment protection, so on. So there are very definite rules. We don't just make it up as we go along.
One of the mediums, Jim, where these issues really collide is on the radio and on TV with freedom of expression. And could you explain to our viewers what is the role of the FCC, and then share with us how do you think that is playing itself out? Do you agree with what the government is doing with those issues?
It's a little bit hard to say what the government is doing right now because the FCC personnel is changing as we speak. But the general idea behind more significant control of the content of communication for what I would refer to as over-the-air media, television, over-the-air TV, and radio is that historically the government, as representing the people, said the airwaves belong to all of us. And we're going to license some of you to broadcast, but when you do so, we can control a little bit of how you say and what you say because it's a limited spectrum. And that has been the traditional role of the FCC, is to regulate the use of the airwaves by its licensees. And over time, it has engaged in various kinds of attempts to restrain the content by TV broadcasters. Most of the time, we ought to recognize that TV and radio censor themselves. It's not the government that does it, but there was at one time something called the Fairness Doctrine, which is a rule imposed by the Congress through the FCC that required balanced reporting. More recently, of course, the FCC in the infamous, now infamous Janet Jackson case fined the over-the-air broadcaster for the bared breast of this young woman at the Super Bowl. There's an example of where the government attempted to regulate by punishing the content-based, making a content-based distinction and punishing as a consequence. The argument is that it can do that more with over-the-air broadcasters because it has control of the airwaves, backed up by the notion that we don't have a lot of ability to control what comes into our homes in that context. Now, is the way the FCC operates good, bad, or indifferent? That's a judgment call. In my judgment, given the impact of modern media, satellite TV, cable, satellite radio, cable TV, all the other input mechanisms, for the FCC to hold on to that one as a means to censor activities is much more problematic. One of the responses I give when I get this question, although it's easy to say, hard to do, being a parent I know that, is you can unplug the TV, you can unplug the radio, you don't have to turn it on if you don't like the content. The other point that I want to make, or like to make about that, is that if you look at what it is that is fine, the fines that are imposed on broadcasters of various things, and compare it with the ordinary fare on radio and television, you have to wonder why they're being so selective about particular content regulation. And that creates issues for me about the ultimate fairness of those kind of regulations.
Jim, something else that you spoke to today, and this all relates to this, I thought you were so clear in talking about the word censor, and you indicated that how do we choose between permitting government to do the censorship, or we do self-censoring. Would you explain to our viewers why, if one turns that or delegates that power to government, what the consequences are versus that we in our own individual lives or families make those decisions?
Well, I see two consequences, one for government and one for the individual. For the individual, it's passing responsibility for making fundamentally difficult decisions to the government, which we generally don't think is a good idea. We like to preserve for ourselves a sense of autonomy. For me as a parent to say, it's the government's responsibility to decide what my children watch on TV or listen to on a CD or listen to or take over the internet, delegates to the government a responsibility that I think that I have. So from that point of view, I think it improperly puts responsibility in the wrong place. From the government point of view, as a citizen, what I have to say is that there is an historic tendency by the government, I think we've seen it over and over again, that if it takes responsibility for being nanny, using that term advisedly, and telling people what they can and can't say and what they should say and what they shouldn't say, the government is people by ordinary human beings who are error-prone and have their own prejudices and viewpoints, and they tend to confuse their own agenda with their power as government officials. And when that happens, I think we all suffer. There are many instances in our past, and I'll go back far enough that many people won't remember, but during the Vietnam War, for example, where our President of the United States quite deliberately set out to use agents of government to restrict people's ability to dissent. And that's what happens when you pass responsibility for making those judgments to the government.
One follow-up question, that is that if we decide in many of these arenas and subjects that we will allow government to make those decisions, what guarantees of protection we have of what the definitions will be or the guidelines? In other words, where will they draw the line in not just one subject, but a numerous number?
Well, I think that's a fundamentally important question. What will legislators, the executive branch, use to make those kinds of decisions? And as I said a moment ago, I think there tends to be a confusion that the personal agenda of people who run the government tend to dominate that kind of discussion. Their point of view about issues of morality and ethics tend to dominate. And that's not necessarily what we want in a society that's dedicated to a liberal understanding of everybody's individual rights and freedoms. And so for the government to do that risks putting power of the government and its ability to suppress on one side of many public debates, which is not healthy in a democracy.
Janelle Burke.
Many people think of free speech as just being free speech, but in fact, not all speech is protected. Can you give us some examples of speech that is not protected? And then can you, as a second part of that question, talk a little bit about criticism of public officials?
Okay. There are many examples of circumstances where the court has recognized that the content of speech can be regulated. The two areas that come to mind most readily are when persons engage in direct assaults on other individuals, directed communication at them with assaultive language that causes a reasonable apprehension on the part of the other person. That is not speech that is protected. That's similar to the famous metaphor about shouting fire in a crowded theater. That is not protected because the risk of damage is so enormous relative to the value, the communicative value of the speech. So that's one context. Another context is one that has plagued us or intrigued us or focused our attention for so long, and that is sexually oriented material. The court has, over time, developed some pretty clear standards that there are certain kinds of depictions of sexual activity that have no redeeming social value, so are not treated as speech. There are subsets within that, but that's a basic notion. And then the one that's most particularly gained attention in the ascendancy over the last few years is the issue of depictions of children and pornography. And a different standard applies there. In the interest of protecting children, we allow more regulation of the content of that kind of speech.
And the second part of my question has to do with criticism of public officials.
On criticism of public officials, thank you. There are a series of cases starting way back in 1962, a case called New York Times against Sullivan, in which the court said the risk of suppression of communication about matters of politics means that individual public officials who claim that they have been hurt, slandered, libeled, defamed, has to take a back seat to the need for robust and open debate about matters of politics. So the general rule that we've established there is that we are pretty free to criticize government officials, just like we can criticize public officials like public figures like Johnny Cochran, unless that person can demonstrate that we have been malicious, actually intending to do harm, in total disregard of what passes for the truth. And so we sacrifice, if we are in the public eye, a certain amount of our reputational interest, our privacy, if you will, because the court has made the judgment, which most of us accept, that is, most of us citizens, that too bad, you're in the public eye, you are a public official, there's a certain space around you that we have to allow attacks on you in regard to your behavior. And so we pretty much give full rein to First Amendment rights in that context.
All right.
I want to have you explain a comment that you made a little bit earlier about hate speech. And I think what you said, Jim, was that if we try to stop hate speech, it doesn't stop the person from thinking those thoughts. And I agree with you in theory, but I'm not sure if I agree with people being able to say what they want to say. So could you explain that a little bit further?
Well, there are lots of different explanations. First, you might have to be very considerate of the context in which the speech takes place. If it's in the context of an otherwise violent encounter, that might be a different circumstance. There's a famous case in the United States Supreme Court a few years ago about cross-burning, in which the court said that when cross-burning is used intending to intimidate another person because of our historic understanding of the purpose of cross-burning, it won't get very much First Amendment protection. The difficulty beyond that I have with hate speech is twofold. One is definitional. What do we mean by hate speech? What is it that you include in that topic? And that leads to a second difficulty with over-regulation of hate speech, and why I have some difficulty with many campus speech codes, is that most of the time the standard is what the individual who hears it defines as hateful. And as soon as you do that, you have to understand the consequences. As much as we don't like racist, homophobic, sexist speech directed at individuals or groups, we have to recognize that if we punish people for saying that and we depend on the subjective impression of the person that's the hearer, that person exercises an effective veto over public discourse. And I think the risk of suppressing speech as a consequence are too high, most of the time.
My follow-up would be the very famous old saying is, will you allow the camel's nose under the tent? And so is that you're indicating that, where does it stop?
Precisely, on both levels. But one, the definitional inquiry, hate speech is a nice term, but you have to tell me what it means. And if you're going to say it's the judgment call of the individual who hears it, boy, personally, I have lots of room to punish people for what they have to say about me, and that's the risk.
It would cause a lot of silence for a lot of us. A lot of our viewers are in Canada, our great friends in Canada. We get hear from them. And for a moment, would you compare the United States and Canada in relation to this constitutional basic question? Do we have more free speech, or our Canadian friends, or is it very similar?
I think it probably depends on the context, and thank you for asking me that question, because as it happens, I'm preparing to teach a course in comparative civil liberties between Canada, the United States, India, and the nation of Italy. I think one of the things we can say, particularly in the context of hate speech, or speech that's denigrating of other groups and individuals, women, First People, and so on, is that the Canadian courts have been more inclined to support the equality principle, which mitigates, kind of moves us against allowing lots of room for that kind of talk, rather than our tendency to support a more liberal, libertarian view that individuals have the right of free expression. And I'm intrigued by that. I don't know why that's the case. Some of what I've read and I've thought about, and based on visiting in Canada and getting some sense of the culture, is that The Canadians tend, as a matter of their history, to be more based on a communitarian ethic than an individualistic ethic. And if that is true, and I don't know that it's true, but if it is true, then it makes more sense that they would err on the side of protecting community values, even if individual speech rights might be more restricted. And so I think there is a difference. I don't think it's a profound difference. In fact, some of our Canadian friends and academics that I've read about are very concerned that the Canadian example and system is becoming Americanized, that it's going too far in favor of the American model on free expression rather than sticking with the Canadian view, as is the case with Canadian culture generally. There's lots of, as we all know here, concern about too much American influence in Canada.
Is there some area where they are more libertarian or liberal in free speech than we?
I can't tell you one offhand. I think that the attitudes of letting people be tends to be more pronounced, at least in some parts of Canada, and as a consequence, a little bit more inclined toward allowing free expression. But I don't really have the knowledge yet. Check with me in 6 months and I'll let you know.
Okay. We just, now it's almost out of time. Is just in a very, very brief comment, what area would you recommend that there should be the most restriction on free speech?
What area would I think would be where the most restriction of free speech? I think probably the area that's of most concern to me is public exposure of private facts. I think that we have a very difficult time in this complicated country in which we operate, and as things get more and more open and the government demands more and more information, that the private lives of ordinary individuals are very easily exposed. And I think that that's an area where I think we have to be a little bit careful. I've been interested in the issue of informational privacy for a long time. Mm-hmm. And I think that's an area that we need more careful attention.
We just saw that, I think, in Atlanta with Choice Points, and they've been before the Senate Banking Committee on that issue. Ladies and gentlemen, we are so enjoying this series on Hot Talk, and we want to thank Professor James Vacher. He's got an incredible wealth of knowledge and he articulates so well. And thank you for being with us both at the lecture here today and on the program. And Jim, we hope you'll be back to visit with us soon.
As usual, I've enjoyed myself immensely.
Thank you. Ladies and gentlemen, join us again next week, and we will continue this topic on Hot Talk. Until then, please have a good week. I am Tony Stewart.
Recorded on the campus of North Idaho College, Public Forum is the longest-running in-house college production on PBS. Each episode is pre-recorded live and is an educational outreach from North Idaho College. Please join us at this same time next week for another edition of Public Forum on this public television station.